Thank you all for joining us for today's virtually speaking webinar on E-Verify compliance and immigration employment law updates. You'll find today's webinar recording on our YouTube channel, which will be linked on our webpage, tnworks.org, along with all of our past virtually speaking webinars in our online library. All who registered for today's webinar will receive an email with a link to the recording as well as all webinar materials. As questions arise during the webinar, please go ahead and enter them into our Q&A box, and we'll cover them at the end of the presentation during the question and answer segment of today's webinar. We encourage you to follow us on social media for future topics and events. Our Facebook pages are American Job Centers of Northwest Tennessee, American Job Centers of Southwest Tennessee, and American Job Center of Greater Memphis. I'm going to go ahead and introduce today's panelist. We have Lisa Watson. She is the Director of Labor Standards with the State of Tennessee's Department of Labor and Workforce Development. Also joining us is Meredith Maroney. She is an attorney at law with Rainey, Kizer, Reviere, and Bell. So without further ado, I would like to go ahead and turn today's webinar over to Meredith. We're thankful to have their expertise and look forward to hearing their presentations today. Meredith?
Thank you, Ginger. I'm going to share my screen. Immigration law update. Now, it probably feels like a whirlwind since January with all of the new executive orders and initiatives that the current administration is taking on. So I'm hoping to break some of that down for y'all today and go over what you can expect in terms of worksite enforcement. So let's just go ahead and get started. Oops, sorry, I went too fast. So here is what we're going to cover. The executive orders that have come down, which is going to be very brief. Immigration law as it stands today, and the Form I-9. And I will tell you that the Form I-9 is going to be the bulk of our discussion today because that is really the tool that the current presidential administration is using to enforce its immigration laws. So executive orders, there have been so many. I read through all of them in preparing for this presentation. Most of them really do not affect employers. They do affect those who are in our country illegally or who are on visas who have overstayed them, but they really don't have a direct effect on employment law. There is no executive order that affects employers. So everyone's familiar with President Trump declaring a national emergency at the southern border. And if you've been reading the news, you've seen the Alien Enemies Act that has been invoked to deport alleged Trinidad gang members. And of course, the Protecting American Communities from Criminal Aliens. So all that does is direct the U.S. Attorney to publish a list of designated sanctuary cities and to consider pulling all federal funding from those cities and localities. And it's also last night, President Trump announced that he intends to enact a travel ban, which he had one in his first administration for about 7 Muslim majority countries. And he is doing a separate one now for some Muslim majority countries, but also other countries, including Haiti. And then he is also taking a serious look at countries like Venezuela, not necessarily banning individuals from coming to the United States from those countries, but harshly scrutinizing whether they should be here and whether they should be admitted, whether it be for non-immigrant purposes or immigrant purposes. And in light of the terrorist attack that happened over the weekend, the Trump administration has announced that they would like to deport those who are overstaying their visas. And I think that will have a direct effect on employers insofar as the Form I-9, and we will get to that later. So U.S. immigration law. So there are numerous immigration laws, but I just want to touch on the ones that are key to employers. So under the Immigration and Nationality Act of 1952, it is unlawful for a person or other entity to hire or to recruit or refer for a fee for employment in the United States an alien, knowing the alien is an unauthorized alien, with respect to such employment. It is also unlawful for a person or other entity to fail to comply with the verification system established by the INA, evidenced by the Form I-9, in hiring. Additionally, it is unlawful for a person or other entity, after hiring an alien for employment, to continue to employ the alien in the United States, knowing the alien is or has become an unauthorized alien with respect to such employment. However, if a person or entity establishes that it has complied with the INA's verification system with respect to the hiring, recruiting, or referral for employment of an alien in the United States, and that would be the Form I-9, and if you're required federally to engage in E-Verify, then that person or entity has an affirmative defense if charged with violating the INA. So you're probably wondering, what on earth does all that mean? Then I-9 compliance is for you. This section is going to be the most important that we discuss today. And I encourage you to really pay attention, because the devil is in the details in a Form I-9. You could do everything right, and if you miss one little thing that may feel like a technicality, you have violated the law and you will be eligible to receive sanctions and penalties. So I strongly recommend really honing in on this portion of the presentation. So what is the Form I-9 requirement? All employers must complete a Form I-9 for employees who are citizens and non-citizens. This has been the law since 1986 under President Reagan. And this is true whether you have one employee, 1,000 employees, 1,000,000 employees. Absolutely every employer must complete a Form I-9 on every single employee. The government has published an online handbook to help guide employers through the I-9 process. So if you have additional questions after this presentation and you're going back and reviewing your I-9 process, you can consult the M-274, which is the government's handbook on how to complete Form I-9 and troubleshoot some questions you may have. So there are 3 steps I'm going to go over with regard to completing a Form I-9. The first step, and our most lengthy step, is properly completing the Form I-9. This is make or break for employers. The most important thing I want you to take away from this presentation is that you must use the current version of the Form I-9. Even if you have properly completed the Form I-9, if it is not the current version, you have violated the law. So a lot of governmental documents have an issue date and then an expiration date. So you will look to the expiration date to see if it is the current version of the Form I-9. And to make it super confusing, there are 3 current versions of the Form I-9. And I am going to share with you all in this presentation what the most current version looks like, so that you can double check your Forms I-9 and make sure that you're using the right one as you hire employees. So there are 2 Forms I-9 that were published on August 1st, 2023. One has an expiration date of July 31st, 2026, and the other has an expiration date of May 31st, 2027. I have no idea why the government decided to have 2 different versions of the same document that expire at 2 different times, but if you use either of those, you are current. Now, the most up-to-date version of the Form I-9 is one that was published under the Trump administration on January 20th, 2025. And it expires on May 31st, 2027. That is the one I'm going to use today when I show you examples of what the Form I-9 looks like. So this is a warning. If you just have a folder of forms that you use for your onboarding process and you've been using the same Form I-9 for years, I strongly recommend that you review and make sure that it is not expired. And if it is, that you download the most up-to-date Form I-9. And I do have a copy of that, and I will give that to the group after so that y'all can use that and look at it for future Form I-9 use. And I know some people have temp agencies that they use to help staff their certain positions at their companies. I strongly recommend that you make sure that these temp agencies are aware of the fact that they must use the current version of the Form I-9. That is very important. You can't just say, oh, well, that is a separate entity from me that handles the onboarding process. So if there's ever an issue that comes up, that's not my fault. I can't be penalized for that. That's not true. You will be jointly and severally liable or penalized under the law, even if you outsource your onboarding, including completing the Form I-9, to a temp agency or another type of HR agency. You will be responsible for that. So that's my big word of warning when you're filling out Forms I-9. Be very careful. It is very detail oriented. Make sure that you complete it in its entirety. And I will go into that now. So section 1 of the Form I-9, the employee completes this. So each employee must complete and sign this section regardless of citizenship status. And this is where the employee shows that he or she is authorized to lawfully work in the United States. It must be completed before the first date of employment, but after the acceptance of the offer of employment. Some employees may not have English as their first language or even their second language, and they may not feel comfortable completing the form. So it is okay for them to have a translator help them, or, there may just be another individual who prepares it for them and there is no language issue. That is what we call a preparer. And those individuals will also need to complete Supplement A, and I will show you all what that looks like. Regardless of whether an employee completes the Form I-9 himself or has assistance, the employee will still be bound by what he or she puts in section 1 of the Form I-9. So this is what the first page of the Form I-9 looks like. Section 1 is this very top section. This is what the employee is going to fill out before the first date of employment. And here you see section 2. This is what employers will fill out, and we'll address that in a moment. But I want to point out at the very bottom of the page, bottom left corner, it says edition 01/20/2025. So this was effective January 20th, 2025. At the very top right-hand corner of the page, it says the expiration date. It's kind of tiny right here, but it says May 31st, 2027. This is where you need to look on your Form I-9 to make sure that you're using the most current version of the Form I-9. This is what Supplement A looks like. It is pretty self-explanatory. Okay, section 2 is what the employer completes. The authorized representative of the employer attests that he or she has examined the employee's documents, that they appear to be genuine, and that the employee is authorized to work in the United States to the best of the authorized representative's knowledge. So in section 2, you will have to review documents that show that the employee is lawfully allowed to work in the United States. There are 2 ways to satisfy. The employee can provide you 1 document from list A or 2 documents, 1 from list B and 1 from list C. So if you've gone through the Real ID process recently, this may seem a little familiar to that. The documents must be unexpired. The employee's name on the documents must match the name on the Form I-9, and they must be the original documents. They cannot be photocopies. And employers cannot specify which documents an employee submits. The employee is the one who gets to make that choice. So page 2 of the Form I-9 is a list of acceptable documents. So this is what you'll look at when you're reviewing the documents to make sure that the document presented is an acceptable document. And here is section 2 again, where you can see what you fill out. And you may notice at the bottom of the big blue box on the lower right side that says additional information, there's a little checkbox that says check here if you used an alternative procedure authorized by DHS to examine documents. And what that means is that employers who are enrolled in E-Verify and in good standing may remotely examine I-9 documents. This is not a requirement, but if you offer it to one employee, you have to offer it to all employees at that hiring site. And for the sake of time, I'm not going to go through every single one of these slides about the remote verification, but you will have access to this PowerPoint and you can go through and review that later. An employer may not request that an applicant or employee present more or different documents than required, refuse to honor documents which on their face reasonably appear to be genuine, refuse to accept a document or hire an individual because of a document has a future expiration date, or accept printouts from the Social Security Administration in lieu of a Social Security card. Okay, Supplement B, which is formerly Section 2 of the old Form I-9. So this is going to be super important for those of you who have employees who are not either U.S. citizens or lawful permanent residents. So if an employee requires re-verification, that means that this is an employee who is only allowed to lawfully work in the United States for a certain amount of time. So you will need to make sure that you have a system in place that is non-discriminatory, where you check every single Form I-9 periodically and make sure that if there is someone who has an expiration date coming up soon where they are not allowed to lawfully work in the United States past a certain date, that you meet with that individual and ask him or her to provide you with their documents that show that they are lawfully allowed to work in the United States again after this first period ends. So it can be really confusing, but it's important this is the most important piece for those who are concerned about worksite enforcement and wanting to comply with federal immigration law. So I'm sorry, I don't know why this is behaving that way. Okay. Re-verification must occur no later than the date that the employee's work authorization expires. And the employer must note the document that extends the employee's ability to work in the U.S. and the new date that the employee's eligibility to work in the U.S. expires. So if you do not already have a system in place where you are periodically reviewing your Forms I-9, I recommend that you establish one. The safest way to do so is just to review all your Forms I-9 periodically to make sure that you take note of who has an expiration date coming up so that you can meet with that individual and get their re-verification documents to make sure that you are in compliance with federal law. If you just pick and choose people, it could be viewed as discriminatory. So it's important that you treat everyone fairly and consistently. Step 2, employers must maintain Forms I-9 for the longer of either 3 years from the date of hire or 1 year from the date of termination. This includes maintaining Supplement A and Supplement B if they were completed for that individual. And I strongly recommend that you maintain Forms I-9 in their own folder. Do not just shove this in a personnel file. That is because in the event of an audit, if ICE comes, they are going to be able to access that entire personnel file, not just the Form I-9, if the Form I-9 is stored in a personnel file. So you don't want a fishing expedition of all of your documentation on each employee. It's best just to limit the scope as much as you can. And by maintaining Forms I-9 in a separate folder, you are able to do that. And then step 3 is what we've already discussed, re-verifying employees when required. And this is what that supplement B looks like. I want to tell you that I have never in my life heard someone mention that in federal government that they are going to start enforcing federal immigration law by looking at Forms I-9, but I heard the border czar, Tom Homan, say that on a news program I was listening to, and that really caught my attention. They are serious about enforcing federal immigration law, and I would venture a guess that because a lot of their other immigration initiatives have been enjoined by federal courts, and this is already existing law, the Form I-9, they are going to really hone in and really try to enforce this portion of federal immigration law. So that could come in the form of on-site audits by ICE, a review of the Form I-9, and arresting employees who are not lawfully allowed to work in the U.S. I strongly encourage you not to resist and get in the way of ICE if they come on site, because this is what they are authorized to do. They are authorized by law to come on site and enforce this immigration law. And I know I'm running short on time, but I do want to just briefly touch on the penalties that you could receive if you violate the INA, which is completing the Form I-9 or failure to complete the Form I-9. So there are several factors that go into a penalty. So just because you violated the law doesn't mean you're going to have the maximum penalty the first time. It could, it just depends on the circumstances. And so this is just a table of some of the monetary penalties that you could receive for violating the INA by not completing the Form I-9 or allowing someone to stay on who needed to be re-verified but wasn't. So what can you do to proactively protect your business? I strongly recommend everyone conduct an audit of all their Forms I-9. Make sure they're completed. Make sure that they were completed on an unexpired form at the time of hire. Make sure that every employee who needs to be re-verified is being re-verified timely. And make sure that you are maintaining the Form I-9 properly. So what do you do if some Forms I-9 are incomplete or completed on an expired Form I-9 at the time of hire? Keep the original Form I-9, complete a new Form I-9 on an unexpired form, prepare a memo that explains the mistake and that the corrected Form I-9 was completed to fix the mistake, and then attach the new completed Form I-9 and the memo to the original Form I-9 and maintain it. This is not going to prohibit you from receiving any penalty from ICE. However, it could help mitigate the penalty that you receive. An employee was not verified timely or re-verified timely. What do I do? There are 2 scenarios here. Either you meet with the employee and ask for the documents and he or she provides them, and then you are able to verify that they're allowed to continue lawfully working in the United States. So you do the memo, you complete Supplement B and maintain it pursuant to federal law to make sure that you have mitigated your exposure to any type of penalties here. Or there's a situation where the employee cannot produce the employment verification documents timely, or does not have employment verification after their most recent eligibility term. At that point, you likely need to terminate the employment to be in compliance with federal immigration law. And you may be wondering, well, how long do I need to give these employees? Typically, employers give employees 30 to 60 days to provide the documents that show that they are allowed to continue working in the United States lawfully. But at this point, it's going to be a business decision, because if you have someone who is not lawfully allowed to, or you don't know if they're lawfully allowed to work in the United States and they're current work visa or other document has expired, you're stuck between a rock and a hard place because the current administration really is pushing to enforce immigration laws at the work site. So you may have to make a business decision, and if that person can't produce the documents in a few days, you may choose to terminate them. There's really no good answer on that, unfortunately. But I did want to briefly touch on that before I turn over my time.
Thank you, Meredith, for all the information that you shared. And we are already getting questions in the Q&A box, so we will get to those after Lisa presents. So we're gonna go ahead and turn the presentation over to Lisa Watson.
So I'm Lisa Watson. I'm with the Tennessee Labor Standards Unit. Today we're going to talk about the Tennessee Lawful Employment Act and E-Verify and what employers need to know as far as Tennessee regulations. So some of the things we're going to cover is what is the TLEA, which is the Tennessee Lawful Employment Act, who is affected by it, E-Verify basics, and why early adoption is smart. For a little bit of history on the TLEA was enacted in 2011. It was gradually implemented by employer size. So in 2012, it was required of anybody with 500 or more employees to either collect documents or e-verify their employees. And then in 2013, it dropped down to employers with 6 to 199 employees. And then beginning in 2017, employers with 50 or more employees must use e-verify. And then most recently, it's dropped down to 35 full-time equivalents for 2023. So with the addition of the phrase full-time equivalent into the newest legislation change, this applies to the total employees under the same federal employer identification number, so the EIN. So whenever the employers are counting their employees, it needs to include the employees in all locations. And employers who report below 35 full-time equivalent threshold must complete the FTE calculation page that's shown on this page during our inspections. So one of the tips we usually tell employers is if they're already close to that 35 number, it would be a good idea to go ahead and enroll in and use E-Verify since they're already so close, because they don't want to go over and then not have somebody E-Verified as required. A little bit about the word problem you see on the page on the screen. That is how we determine how many people are considered full-time equivalents. We need the employer to properly report how many full-time equivalents they have. This can be a little bit complicated. As you can see on here, it looks like a word problem from, maybe middle or high school, where it says if Bob works 32 hours per week, Bob would be 0.8 of an FTE, due to the fact of you would take his 32 hours per week average, divide that by 40, and that gets you the 0.8 FTE. Then at that point, the employers would combine the total number of FTEs for everybody in the company and come up with a number. So for the example on this page, it looks like they would have 47 FTEs. So therefore, they would be required to use E-Verify. And this form can be a little bit difficult for employers to complete. We've run into that sometimes with employers. They don't really know what we're asking for, so we have to work with them. And especially it can become even more complicated due to things like changes in the employee's hours per week or employee turnover. However, we strongly encourage the use of E-Verify even if the law doesn't require it, just because it makes the process simpler on employers as well as the people doing the inspections as well. So whenever we say why use E-Verify, it's obviously required for employers with 35 or more full-time equivalent employees. It also simplifies compliance, and it shifts some of the verification burden onto DHS and SSA, which is the Department of Homeland Security and the Social Security Administration. It avoids invalid documentations and documents from unapproved states. So we have roughly half of the states in the country have as strict of issuance requirements for identification as Tennessee. So part of the TLEA requires us to either get an ID from employees from the state of Tennessee or from a state that has as strict of requirements as us. So since that can change sometimes, it makes it even more complicated for an employer to know which IDs are acceptable by TLEA standards and which IDs aren't, which is another reason why we suggest using E-Verify. So the form that you see here is a lot simpler than the form you saw on the last page, because the only thing that we're really asking for on here is to basically have the representative's printed name, signature, contact number of the representative, the date of the company's E-Verify enrollment, and the date that they fill this out. And basically what this is saying is that the person who generated the E-Verify report from E-Verify hasn't gone back in and altered it in any way. It's just they're pulling the data and providing us the data that came from their E-Verify. So like I was talking about earlier, the acceptable documents versus E-Verify can be a complicated thing. So TLEA requires employers of 34 or fewer FTEs to either keep a copy of one of the 11 acceptable documents or enroll in E-Verify and verify employment authorization with the E-Verify program. The burden of choosing to accept documents is complex, as employers who choose to accept documentation rather than utilize the E-Verify program are required to only accept valid IDs. And E-Verify can simplify this process for employers. So for instance, I'm not going to read off every one of the 11 acceptable documents, but like we said earlier, the Tennessee driver's license or photo ID, or a valid driver's license or photo ID from another state where the requirements are as strict as ours, a birth certificate issued by a U.S. state, or even something along the lines of a certificate of citizenship, or a valid alien registration document, or other proof of current immigration registration recognized by the United States Department of Homeland Security that contains the complete legal name and current alien admission number or alien file number. So something important to note is if the employer has fewer than 35 employees, they're not required to use E-Verify. However, it's strongly encouraged, as it relieves the employer of the burden of independently verifying the authenticity of each document and ensuring that the document is considered acceptable by the Tennessee Lawful Employment Act. Why I say that is here recently we have seen a severe uptick in fraudulent documents that employers have taken. Either they were somebody else's documents that have a name change on them, or it's just a completely fake document. So that's one reason why we strongly suggest E-Verify, because E-Verify, once you put the information in there, it'll come back with an error message saying, tentative non-confirmation based on the fact that the information isn't matching what they have in their system. So for E-Verify in action, what the employer would do is input the Form I-9 information into E-Verify. The system checks against the DHS and the SSA, and then the result will either be employment authorized or tentative non-confirmation. And this is pulled from E-Verify's website. So if in the event that an employer receives a TNC or a tentative non-confirmation for a mismatch, this is the time frame that they would need to get everything handled. So once they get that TNC back, the employer should immediately notify the employee of the TNC. The employee has 10 federal government workdays to make a decision to take action or not to take action, and to give that decision to the employer. If the employee decides to take action, employer needs to refer the case to the Department of Human Services or the Social Security Administration. The employee must contact DHS or SSA within 8 federal government working days. Once the employee receives employment authorized result, the employer can continue to employ the individual. If a FNC or final non-confirmation result is generated, that means the employee has not been authorized to work. Continuing to employ an individual would be a violation of the TLEA at this point. So some of the common TNC reasons can be something as simple as entry errors or typos. We're all humans. Sometimes we hit a 1 instead of a 2. So that can be something as simple as that. It can also be a name mismatch, an unreported status change, or information not updated with the SSA or DHS. The penalties for non-compliance can be anywhere from $500 to $2,500 per employee. It goes from $500 for the first violation, $1,000 for the second violation, and $2,500 for the third or further violation per employee per employer. Also, the employees or employers are given 45 days to remedy the situation, to get proper documents, and after that point, if they can do that, we may be able to work with them on the first offense. Sometimes there are warning opportunities available for the first offense if it was deemed to be an unknowing violation. However, if the employer fails to correct the problem and it goes on for longer than that 45-day window, there is the possibility of a $500 a day per person fine to be implemented on them. So those penalties can get excessive really quickly. So we always encourage everybody to make any corrective actions required within that 45-day window to avoid the, heightened penalties. There's also some record keeping benefits for E-Verify. I know we run into a lot of times where employers say they don't really have enough room to keep paper copies, which is fine. Paper copies are becoming more and more a thing of the past. So E-Verify allows electronic storage for their verification documents. So no need to keep the ID copies for Tennessee purposes, except for minors, because they also fall under the Child Labor Act, which requires the proof of age to be kept on file for them. The E-Verify also creates audit-ready reports when available, so you can either make a quick audit report, which will pull up everybody that's been hired, or you can also do individualized authorization reports for each individual. A little bit of caution that we've noticed before is companies can use third-party vendors to E-Verify their employees. I would just caution you guys to make sure that you download the E-Verify result as soon as they become available, because changing vendors can mean losing access to that information, and employers are responsible for the records even if outsourced. So even if it is somebody else doing your E-Verify, you have to make sure that it is your responsibility to keep up with it. So this could be handy if the employer chooses vendors, as we've encountered problems with employers being unable to access their data after serving their agreement to a third-party vendor. Also, we run into it before where employers believe that just because the third party is doing the I-9 that they are doing E-Verify as well. So just make sure with your vendor that they are also doing E-Verify if you're required to E-Verify your employees. So a little bit of final thoughts on it is requirements are expanding, as you've seen with the history of it. Each time it changes, the number drops lower and lower. There's certain states that already require E-Verify for any number of employees. Violations are expensive, so we recommend E-Verify because it's free, simple, and it's an extra layer of protection for the employers. And that is the end of mine.
Thank you so much for your presentation. Do you recommend using the E-Verify Plus capabilities to limit errors and omissions by employers and employees on the Form I-9?
I guess I would just reiterate what I said in my presentation. If you were going to remotely review documents, that's more of just a convenience factor than a recommendation, but you can do that, but just make sure that you were doing it for all employees. You can't just selectively do it for some. And I apologize if that was not actually the question. I'm happy to address that later.
Well, the Q&A box is open, so if they want to clarify their question, they can
Yeah,
always jump
I'm
back
happy to,
clarify.
happy to take another stab at it.
How can the employer be liable when using an agency if the employee is not considered an employee of the employer, but of that agency? I assume they're speaking of like a staffing agency here.
Yes, that is a great question. And I didn't have enough time to address that fully initially, but in my opinion, the government is likely going to consider the staffing agency and the employer to be in a joint employer relationship, even if that is not the opinion of the employer or the staffing agency. It is possible and potentially likely that the government is going to consider that to be a joint employer relationship. That is how both of the entities would be on the hook.
Okay. Is it still acceptable for the employee to complete Section 1 on the first day of employment?
I presume that this is section 1 of the Form I-9, and the answer is yes. That is the deadline for completing the first section of the Form I-9.
Okay. Is there a way to verify if an employer is registered with E-Verify?
I believe you can look it up on the E-Verify website. There's a search function on there to where you can look it up by employer.
Okay. Are you required to keep a copy of the document you use to verify the I-9?
That's a great question. Under federal law, you are not required to keep those documents. However, if you do decide to keep those documents, you need to be consistent and keep it for all employees, not just a select few or one. However, and Lisa, correct me if I'm wrong, but I think that there may be a state law component that says that you do need to maintain those types of documents. So the best practice may be to maintain it for all employees if that is the case.
Yeah, so the Tennessee Lawful Employment Act requires those documents to be kept on file if the employer is choosing to just accept documents instead of e-verify. Also, those documents can kind of coincide with the proof of age requirements for minors. So if you have anybody under the age of 18, you need to have a valid proof of age document on file for them at the place of employment as well.
This next question kind of goes back over what was just asked, but a little bit additional. So, do the E-Verify confirmations also need to be kept with the I-9 forms in the separate file or to keep them in the same personnel file?
So we don't really have a requirement as far as keeping them in a separate file. We just encourage them to keep the e-verify documents whenever they get it, especially if they're getting it from a third party vendor, so that way they can keep up with it in case we do come out and do an inspection. It's just in their best interest to have it on file, but we don't require them to be kept in a separate file.
Okay. Is the document requirements for E-Verify the exact same documents that are required for I-9?
From what I've seen from the E-Verify system, that is what it's saying online, is that they would just need to put those documents into E-Verify. E-Verify is just basically there to verify the validity of the documents and make sure that it matches what's on file with DHS and SSA.
Okay, this is from another local employer. We have had several come into our office whose IDs have expired, but they applied back in October and still have not received new cards. They do have their receipts, but how do we know if they are approved to work? How do we put this in E-Verify? I know that's very specific, but this is employers are running into things like this and they want to be in compliance, so
Yeah.
looking for answers.
Yeah, I think that real ID deadline really put everybody behind on that. So that would be a question specific that would need to go to E-Verify. Though that group is really responsive on their question and answer section. So you can go on their website and either do a chat or there's a phone number that you can reach them at, and they're pretty quick to respond.
Okay. So E-Verify will directly answer that. Okay, this is a follow-up to that first question we had about E-Verify Plus. So E-Verify Plus allows for employers to enter information electronically through the E-Verify system directly instead of manually completing the paper form. E-Verify Plus allows employers to send employees a link to complete the form I-9 directly into their system. So that was just a follow-up from the employer that had asked that question earlier about the E-Verify Plus. Okay.
It's my, and Lisa, please correct me if I'm wrong, but it's my understanding that the Form I-9 process begins before, maybe just shortly before the E-Verify process on the employee begins, insofar as the employee has to complete Section 1 no later than the first day of employment. So the timing may not, I guess it'll just depend if the timing lines up. But what I would do, even if you are relying on an electronic vendor or an electronic system that is created by E-Verify, or if the Form I-9 ever has an electronic system in the future, I would still make sure that you are completing the Form I-9 correctly, completely, and on an unexpired form.
All right. To the point mentioned earlier, would the E-Verify confirmation be requested as part of an ICE audit? If this is the case, do you recommend we place with the I-9 document?
That's a great question. E-Verify, while it is a federal creature. It's also a state creature. I think that it's possible that if you are supposed to be using E-Verify under federal law, not everyone is, usually it's just federal contractors, I believe, but if you are using E-Verify as required by federal law, it is possible that perhaps they will request that confirmation. But what I'm speaking to today is just the Form I-9. So they definitely will look at the Form I-9. I can tell you that. I hope that helps. I know that's not an explicitly direct answer, but if you are required to complete E-Verify for federal compliance reasons, it may not be a bad idea to hold on to that and keep it in the Form I-9 document.
This is another employer, and they said they may have missed this earlier, but are we able to take IDs electronically, or does it have to be in person? And if not able to accept them electronically, how are they supposed to handle that for their remote workers?
Okay, so I'm guessing that this is for Form I-9. I'll speak to it from that perspective. So if you use E-Verify and are in good standing, you can review documents remotely, but you have to do so for all employees at the hiring site. You can't just do it for one person who remote works and no one else. So if you have all these people who are working at your Jackson location, and if you want to have their documents reviewed remotely, you have to make that option available to everyone. I don't anticipate people having an issue with that, but I just want to be clear that you have to be consistent with how you allow documents to be reviewed if you do go the remote route. But if it is a remote worker who is, and you're not using E-Verify, or you are, but you're not in good standing, you are going to have to review those documents in person.
That wraps up all of the questions in our Q&A box. So I'm going to go ahead and close that out. We're getting kind of close here on time, so I just want to say thank you guys both for the information that you shared today, and want to thank everybody for attending. Again, Meredith, Lisa, thank you so much for the information that you shared. We really appreciate it. And thanks for all of our attendees. Thank you all. Have a great day.